I'm Rodilyn Resnick-Kiniski, and I am the director of Lakehead University Community Legal Services, which is a legal aid clinic located in the Boer-Alaskan Faculty of Law, which is the law school here in Thunder Bay. Today, we're going to be presenting on residential tenancies in Ontario and what you need to know as a tenant. With me is Emma Dew and Andrea Thompson, both of whom are going into their second year of law school and are spending their summer with us. And with that, I will turn it over to them.
Before we begin, Emma will just do a little introduction on a land acknowledgement for us.
We're currently presenting from the traditional lands of the Fort William First Nation, signatory to the Robinson Superior Treaty of 1850. We'd like to offer our gratitude to the people of Fort William First Nation for the care for and teachings about our earth and our relations. May we honor those teachings.
Our presentation will briefly overview a little bit about Lucals. We'll tell you who we are, what we do, how to qualify for our services, and how to reach us. Take a look at the law that applies to tenancies and what those tenancies should look like in most cases. Then we will take a look at major tenant and landlord obligations, and we will discuss some options for tenants when their landlord may not be meeting their obligations. We will then provide some useful resources for tenants in the Thunder Bay area. And finally, throughout our presentation, we will give you some scenarios and how to deal with them if they arise.
So the Lakehead Community Legal Services, also known as LUCLS, is an initiative of the Boer-Alaskan Faculty of Law in partnership with Legal Aid Ontario. We're based on a student caseworker and review counsel model, meaning that our student caseworkers conduct all the work on their own files, but each step is reviewed and approved by review counsel beforehand to ensure quality services for our clients. We serve low-income and vulnerable clients in Thunder Bay and the surrounding region by providing free legal services in areas such as provincial offenses, minor criminal charges, small claims, and landlord and tenant issues. To qualify for our services, applicants must meet our financial guidelines, be within our geographical jurisdiction, and their matter must come within the scope of the matters that we work on. The best way to find out if you qualify is to contact our office. You can also check our website for more information.
Okay, so just as a disclaimer, our students are limited insofar as they cannot provide legal advice to our clients without the approval of review counsel. However, they are able to provide legal information. For the purpose of clarification, legal advice entails providing clients with opinions about how the law would apply to their particular situation, whereas legal information entails providing clients with general information, such as what the law is.
To get us started, we'll tell you a little bit about the Residential Tenancies Act of 2006, also known as the RTA. The RTA is the law in Ontario that governs most rental homes. The purpose of the Act is to protect the parties in the rental agreement, balance rights and responsibilities, and to provide a place for dispute resolution, that being the Landlord and Tenant Board, also known as the LTB. The LTB is a tribunal in Ontario that hears disputes between landlords and tenants. The LTB can enforce rights under the RTA and make orders when those rights are violated. Both landlords and tenants can make applications to the LTB if the terms of the tenancy or the RTA are not being followed. The RTA applies to most tenancies and cannot be opted out of. However, it should be noted that there are some exceptions and limitations. Examples of when the RTA may not apply or where its application is limited include student residences provided by an educational institution, homes intended to be used during travel or vacation, such as hotels, summer cottages, or Airbnbs, nonprofit housing co-ops, shelters, in cases of subletting or sharing the unit with a roommate not on the agreement. In these cases, the RTA still applies between the tenant and the landlord, but not between the tenant and the subletter or roommate, and not between the landlord and subletter or roommate. When the tenant has to share a bathroom and/or kitchen with the landlord or a member of the landlord's immediate family, and more. These are laid out in the RTA in more detail.
So you can find a copy of the RTA, the Residential Tenancy Act 2006 online. However, it is a dense piece of legislation with almost 250 sections and several regulations. The LTB has several resources called brochures that they publish frequently dealing with applications, situations, and processes. This website can be a good first stop when you're first trying to understand your rights. However, care should be taken when referring to these authorities. The law has changed considerably in the last few years, and any resources that you're reading that were published pre-COVID, pre-2020 should be read with great care as so much has changed.
The right to live in a unit usually comes from an agreement between the tenant and the landlord. This legal contract is known as a lease, tenancy agreement, or rental agreement. While this agreement can be verbal or in writing, most residential tenancy agreements signed on or after April 30th, 2018 require the standard lease agreement shown on the slide. The standard lease agreement contains various sections with information about the parties, the rental unit, terms of the tenancy, services and utilities, and any applicable discounts and deposits and more. Once the parties have entered into a tenancy agreement, the landlord must provide the tenant with a copy of the agreement within 21 days, as well as information on their rights and responsibilities and information on the LTB. If for whatever reason the agreement is not put into writing, the tenant must receive a notice detailing the legal name and address of the landlord within 21 days for the purpose of giving notice or delivering documents. Note that the standard lease agreement is 14 pages long. You should ensure that all pages are included in the tenancy agreement along with any attachments.
Okay, so before you sign a tenancy agreement and move in, there are a few things you should know. Primarily, a tenant should be aware of exactly what they're agreeing to. Make sure to review all pages, attachments, any terms that are set out in the contract. There are many free, helpful resources to assist you, such as reputable online sources, and if you qualify, our clinic. We will be providing some further resources towards the end of this presentation. Additionally, be aware that anything in the tenancy agreement that conflicts with the RTA is invalid. Some examples of popular invalid terms include a no pets clause, security deposits, excessive key deposits, cleaning deposits, and essentially any other deposits outside of a last month's rent deposit or a nominal key deposit. Any clause that claims to waive rights, responsibilities, or obligations of either party under the RTA. Any of these terms are unenforceable. A landlord cannot make you abide by these terms. If you happen to pay an illegal deposit, you may seek the return of this money through the LTB. It is important to note that while the standard form lease agreement has been standardized, there are no limits to what a landlord can include as rules and schedules to the lease agreement. These will often include specific rules relating to maintenance, such as how to deal with garbage and recycle, or the rental unit itself.
Once you've entered into a rental agreement, you're entitled to tenant rights, and the landlord has certain obligations to the tenant. As previously mentioned, tenants are entitled to a copy of the lease agreement within 21 days. A tenant is entitled to privacy and enjoyment of the property. A tenant is entitled to proper maintenance of the property. This means that the unit and its appliances, utilities, and grounds are kept up to regulation and health standards. A tenant is also entitled to lawful rent. This means that the landlord cannot increase the rent beyond a certain regulated amount. Per the Ontario Human Rights Code, a tenant is entitled to freedom from discrimination. This includes both during the application process as well as after you become a tenant. A tenant is entitled to security of tenure. This means that once someone starts a tenancy, it may continue beyond the term agreed to in the initial rental contract. So for example, if you sign a 1-year lease agreement, once that year is up, the tenancy automatically becomes a month-to-month agreement. A landlord must also provide you with lawful notices. This means that if a landlord is providing a tenant with any notice, it must be in the proper form and follow the associated rules, such as timelines, methods of delivery, taking proper steps, and so on. If a landlord is responsible for heating, a tenant is entitled to a system that can maintain adequate heat. Here in Thunder Bay, that means a minimum temperature of 21 degrees Celsius or 17 degrees Fahrenheit between September and June 15th. These rights and obligations, as well as those in the RTA and any additional lawful terms in the agreement, apply even when a new landlord takes over the property, provided that you have not already agreed to a new contract with the new landlord.
Okay, so we're going to go into a little bit of a scenario now. So imagine that you've just moved into a beautiful rental unit in the middle of the winter, and we recognize how cold Thunder Bay or anywhere else in Ontario can be. But upon moving in, you realize that the rental unit has no heat. What happens next?
So under the RTA, a landlord shall not withhold, interfere with, or refrain from supplying vital services. Vital services include water, fuel, electricity, gas, and heat. This can be found under Section 21 of the RTA. This means that landlords cannot deliberately shut off any of these utilities unless it is temporary or for the purpose of making necessary repairs. So what you should do when your heat has been turned off or your landlord has not provided you with heat, it's important that you, as the tenant, take photos and document everything. It is very important to have evidence. This can include taking photos of the thermostat. Note that if you don't have a working thermometer, this is something that we can provide. Secondly, you should contact your landlord immediately. If you contact your landlord verbally, that's okay, but it's even better if you contact your landlord in writing so that you have a record of the incidents and the relevant interactions with your landlord. Third, you can apply to the LTB either by yourself or with the assistance of our clinic. I'll discuss in a few more slides about the LTB. We have another scenario here. So let's say you've happily moved into the rental unit and you've now sorted out any of your heat issues, but the landlord continues to come into your rental unit unannounced, and this makes you very uncomfortable. You've not given your landlord permission to do this. Is your landlord actually allowed to do this? Is your landlord able to come into your rental unit unannounced and for no reason?
Well, your landlord can only enter the rental unit in accordance with the RTA. A landlord may enter a rental unit with written notice given to the tenant at least 24 hours before the time of entry under the following conditions. 1, to carry out a repair or replacement. 2, to allow a potential mortgager insurer to enter the unit. 3, specific inspections to determine if the unit is in a good state of repair or fit for habitation. And 4th, for any other reasonable reasons for entry specified in the tenancy agreement. If written notice is provided, the landlord must provide the day of entry and a time of entry between the hours of 8 a.m. and 8 p.m. Under the RTA, your landlord can enter the rental unit without written notice in cases of emergencies or if you, the tenant, has given consent to the entry at that time. The landlord can also enter without written notice if the lease agreement requires the landlord to clean the rental unit. Okay, so moving on to another scenario about unlawful deposits. In the next scenario, you want to move into the rental unit and the landlord asks you to pay a key deposit, last month's rent deposit, and a pet deposit for your beautiful dog. Which of these is allowed and which of these is illegal? Let's talk more about this.
In addition to rent, a landlord may charge you for last month's rent deposit and a nominal key deposit, not exceeding the cost of replacement. Once the tenant returns the keys at the end of the tenancy, the landlord is required to give you back the key deposit. However, regarding the pet deposit, the landlord cannot charge the tenant for a security deposit, damage deposit, pet deposit, cleaning deposit, or any other deposit outside of those just mentioned. The landlord also cannot charge the tenant for repairs or cleaning of normal wear and tear. You are entitled to any interest made on your rent deposit, and this should be paid out yearly or applied against the tenant's rent. Continuing on, let's talk a little bit about maintenance issues. So let's say you've moved into a rental unit, but there's a ton of problems going on. Your stove is broken and there's a hole in the ceiling and the railing is loose. All of these problems were issues before you've moved in. Are these issues your duty to remedy? Is this your responsibility to fix?
Well, under the RTA, landlords are responsible for repairing and maintaining rental units so that they are in a good state and fit for habitation and in compliance with health, safety, and maintenance standards. This is the case even if tenants were aware of any issues or damages before moving in. Therefore, you should contact your landlord immediately if any of these issues arise, preferably in writing, and also take photographic evidence of these issues.
If your landlord fails to comply with the RTA by not providing you housing that is in a good state and fit for habitation, you can file with the LTB.
So the most frequent way that landlords are able to avoid being responsible for maintenance issues is if tenants can't prove that they've informed their landlords of a specific problem. We strongly recommend that you communicate with your landlord via text message or email. We recommend this so that when you send texts or emails, if you take a screenshot of what you've sent them, you can save those screenshots. This is helpful as having this evidence on hand with smartphones that are able to unsend messages now, it makes it a safer way to store your evidence. This makes it clear that the landlord has received the message and eliminates any possibilities that the text message didn't go through and you have that evidence on hand. On an Android device, you press the power down and volume down button at the same time to save a screenshot. And on the iPhone, it's the volume up and power down button. If you want to be extra careful, email yourself the screenshots that you're saving. This will eliminate any possibility that a lost phone would result in lost evidence and create a record with a date stamp of when the screenshot was taken.
Now that you know what the main tenant rights and landlord obligations are, what can you do if the landlord's obligations are not being met? First, try to have open communication with your landlord. If both parties can agree to a suitable remedy, the issue might be quickly resolved. They can't fix something they don't know about, and once they're made aware of the issue, they're obligated to address it in a timely fashion. If the tenant is dealing with mold, pest, or other health or safety concerns caused by the home, the tenant should contact the local health unit so that they may record it and take necessary steps to assist. The tenant should also ensure that they are keeping all communications in writing and documenting any issues by keeping notes and pictures. This will support the tenant's case initially with the landlord, but also later on if the matter goes to a tribunal hearing. In any event, the tenant cannot withhold rent for outstanding maintenance issues. While the tenant must continue to pay rent, they should keep a record of any and all losses or damage suffered during this period, as the LTB may order you compensation or a rent abatement if the matter goes to a hearing. If the tenant withholds rent, that allows the landlord to initiate eviction proceedings.
So generally, a landlord may only increase your rent by a set amount once every 12 months. Currently, the rental increase guideline for 2023 and 2024 is 2.5%. A 2.5% rent increase means that if you rented a property for $1,000 per month, the landlord can increase the rent to $1,025 a month. However, if you move into a rental unit that was built after November 15th, 2018, this cap on the lawful rental increase does not apply.
Moving on now to discrimination. Under the Ontario Human Rights Code, everyone has the right to equal treatment, and this is no different when it comes to housing matters. Your landlord cannot discriminate against you as an applicant or a tenant due to your age, color, race, abilities, gender identity or expression, sex, public assistance, or any other protected ground. If you believe that you have been or are being discriminated against, you may have a case at the Human Rights Tribunal. Please be aware that this is also an area that locals may be able to assist you with. And if you're in the Thunder Bay District, you can contact our office for more information.
Okay, so speaking now on eviction notices. A tenant should know that a landlord cannot evict you unless they follow the rules set out in the RTA. A landlord must give the proper tenant notice using the correct LTB form to start the process of eviction. A landlord may only commence this process in certain circumstances. An eviction can be for cause, such as when the tenant is not paying rent on time, damaging the property, or if they are substantially interfering with other tenants. An eviction can also be without cause, such as when the landlord requires the unit for their use or the use of their immediate family, or when the unit is being condemned, demolished, or converted. In any case, if you receive an eviction notice from a landlord, don't panic. Read the form carefully, as it will often tell you what your options are as a tenant. Most importantly, know that you do not have to move out if all that's been received is this notice. In order to enforce the notice, the landlord must file an application with the LTB and then attend a tribunal hearing. However, it's important to note that there are numerous technicalities that can lead to an otherwise valid eviction notice being deficient. For example, if the landlord gets the date wrong on the form or misspells your name, this can be crucial to the application process. It's always important when you notice these mistakes to get proper advice and not assume that your landlord is correct. The tenant should receive notice of this. The LTB will hear from the landlord and the tenant if they choose to participate and make a decision as to whether the eviction should be ordered. If and until the tenant is served with an order from the LTB evicting the tenant is not required to leave the home. This is important to take note of because if the tenant does move out prior to being served with an LTB order, the tenant may not be left with many options. If the LTB does issue an eviction order, it can only be enforced by the sheriff, otherwise known as a court enforcement officer. The tenant should immediately seek legal advice if you receive an eviction notice from your landlord. Once notified in accordance with the RTA, it is often not long before the landlord can file an application to the LTB. Please note that Lucals is not able to assist with eviction matters. We refer all eviction matters in the Thunder Bay area to Kinna Awea Legal Clinic, and we will be providing their contact information later on in this presentation.
Now that we've addressed some of the major tenant rights and landlord responsibilities, we will briefly address some of the tenant obligations and landlord rights that you should know. A tenant is responsible for keeping the unit clean up to the standard that most people would consider ordinary or of normal cleanliness, paying rent on time, not causing or allowing guests to cause deliberate or negligent damage to the unit, and if this occurs, the tenant is responsible for its repair. The tenant is also responsible to not interfere with the landlord's rights or obligations. The tenant is responsible for not interfering with the reasonable enjoyment of other tenants and the use of their units. And the tenant is obligated to keep the locks the same unless there is permission from the landlord to change them. The landlord has the right to collect a last month's rent deposit that is no more than the cost of rent for 1 month. They can increase the rent in accordance with the annual guidelines or for other purposes in the RTA, as we've mentioned. And amongst other things, they can apply to the LTB to request to end the tenancy in accordance with the RTA for various reasons, some of which we've already touched on.
So now that you have some more information on what tenants' rights look like, if you or someone you know believes those rights have been violated, you have several options. You may access any of the helpful online resources such as the LTB website, which is where you will find information related to the law, rules, processes, frequently asked questions, LTB forms, and more. You may also find resources on the Clio Steps to Justice site under the housing category. As mentioned previously, if you are dealing with mold, mice, cockroaches, or other health and safety concerns, you should contact your local health unit. Here we have the phone number for the Thunder Bay District Health Unit. Of course, in cases of emergency, you should call local police, fire, or ambulance services or 911. And as always, it's highly recommended that you seek out legal advice. Kinna Awea Legal Clinic also assists with landlords and tenant matters in the Thunder Bay District, primarily eviction matters. And lastly, if you do not qualify for our clinic services, we recommend that you contact the Law Society of Ontario's referral services, where you can connect with a lawyer or paralegal who may be able to assist you and provide a free consultation. Or take a look at the Thunder Bay Law Association's website for a list of local lawyers and paralegals that you can contact.
So that brings us to the end of our presentation. Thank you all for allowing us the opportunity to present this information, and we've included our contact information here again in case anyone needs it.